May it please the Court, my name is Norton, initial K. I appear on behalf of the accused, Mr. George Hoffman. Mr. Hoffman is charged with one count of burglary pursuant to Section 419 of the Queensland Criminal Code. He is an intellectually impaired Aboriginal man from Rockhampton. Your Honour, the Crown's case relies completely on the verbal admissions made by my client, including circumstantial evidence. However, the defence submits this application under Section 590AA, subsection 2, paragraph E of the Queensland Criminal Code. The defence seeks that this court exercise its discretion in excluding the Crown's evidence relating to the confessions made by my client to police on the 17th of August 2019. I submit this evidence be excluded on the following grounds. Firstly, it is submitted that the evidence in question was obtained in contravention of various statutory requirements, namely the Police Powers and Responsibilities Act, or the PPRA, and the Queensland Evidence Act, hereinafter referred to as the Act. Police have contravened public policy, and I submit that my client has no case to answer. The identification of the person who actually committed the offence cannot be established by police apart from my client's admissions, which were unlawfully obtained by coercion. Secondly, I submit that my client's admissions occurred due to gratuitous concurrence and therefore hold substantial prejudicial weight. It is submitted allowing this evidence would be grossly unfair to the accused. Due to the history of colonisation of Indigenous people, there is a tendency for individuals, including my client, to agree with statements put to them by people in positions of authority, despite the fact they disagree. My client's confession was obtained by physical force and police coercion. My client was intimidated by police and did not understand the consequences of his answers. Initial questioning of my client was not electronically recorded, as mandated by Section 436 of the PPRA, making the presumption of exclusion applicable. Your Honour may choose to exercise the discretion to exclude evidence which is more prejudicial than probative, as in the Queen and Hasler. In respect to my first submissions, I submit that the police who engaged my client failed to comply with their legal obligation under the PPRA. Specifically, may I refer the Court to Section 418, subsection 1A, which states, before a police officer starts to question a relevant person for an indictable offence, the police must inform the person he or she may telephone or speak to a friend or relative to inform the person of his or her whereabouts and ask them to be present during questioning. My client was unlawfully questioned by police who failed to obtain valid consent to search his backpack as a suspect during initial questioning. From the time of arrest to the time of arrival at the police station, there was a further 10 minutes prior to an electronically recorded interview where my client was later advised of his right to silence after questioning. There is no information to suggest this evidence would diminish or be unavailable at a later time. Your Honour, if I may refer the Court to Section 420 of the PPRA, a police officer must inform legal aid that they have an Indigenous person in custody for an offence, unless the Indigenous person in custody has arranged for their own legal representative. My client indicated to police that he did not have a lawyer. Police breached their statutory obligation by failing to contact ATSLs to advise them my client was in custody as a suspect. English is a second language to many Indigenous people, and therefore, under Section 131A of the Act, an interpreter should have been made available to my client to fully understand the charges against him. Police questioned my client with the knowledge that he may be intoxicated due to the smell of alcohol on his breath. Police failed to suspend the interview until they were reasonably satisfied he was no longer under the influence, as mandated by Section 423, subsection 2 of the PPRA. My client was not fit to understand the nature of the questioning provided, whereby his answers could be misleading. If I may refer the Court to the case of the Queen and LR, in whereby a confession obtained by police was excluded on the grounds the accused was intoxicated and not provided with access to a solicitor. Further, Section 21A of the Act identifies my client as a special witness whom, due to his intellectual impairment, may be disadvantaged. My client, as a vulnerable and special witness, was entitled to multiple protections which should have been afforded. He was not advised of his right to silence. He was unlawfully questioned by police whilst under the influence of alcohol. Police failed to contact ATSLs to advise that my client was in custody or provide an appropriate support person, a right he did not waive. And finally, due to his intellectual impairment, he he was unable to fully understand the charges against him. As an intellectually impaired person under Section 422 of the Act, my client should have been allowed to speak to a support person and informed of his right to silence. At the court's discretion, an expert witness may be obtained to determine my client's ability to give evidence based on these factors. Further non-compliance occurred under Section 431 of the PPRA, subsection 1, where police failed to caution my client prior to questioning to ensure that he understood the information. Your Honour, you have the discretion to have this evidence excluded, as the information obtained from my client was done so unlawfully and without regard for public policy. In order to exercise that discretion, may I assist the court by referring to the case of Bunning and Cross, which provides 5 factors which must be established on the grounds of public policy, which supports the evidence in question to be excluded. Improper police conduct towards my client has clearly breached statute, and the severity of the offence is slight and of an insubstantial nature. In relation to the second ground of my application, the submission of this evidence would be unfair to my client, subject to the Christie discretion. If I may refer the court to Section 130 of the Act, the exclusion of evidence, as in the Queen and Hasler, should only occur whereby the questionable evidence is only of a slight probative value and the prejudicial effect is significant. 2 key factors considerably determine that the probative value to be considerably low and the prejudicial effect quite considerable. The probative value of my client's admissions must be lowered due to the unlawful conduct by police. My client never admitted to the alleged offence, making the evidence inadmissible. Your Honour, it is submitted that the court considers the admissions made by my client to be excluded and that my client has no case to answer.